When we had lots of breaking and enterings, we had something called a clean slate plea. Most of these were young men, and we would offer them polygraph. We had a polygraph operator on staff, and we would grant them immunity on any other property crimes. Didn't include arson, assault, or sexual assaults. If they cleared up other breaking and enterings. Several different occasions in the course of clean slates, we cleared up like 40 B&Es. We'd arrest the other two guys and they do a clean slate, and we don't see that sort of thing anymore, fortunately, and the polygraph is a forgotten artifact. Good afternoon, Ms. Canfield. Thank you for joining us.
Good afternoon, Your Honor, of course.
We're going to return to the matter of people versus...
This hearing starts with a serious charge. 2 count of criminal sexual conduct in the 3rd degree involving an incapacitated victim. And because the defendant is charged as a 3rd habitual offender, he's facing exposure of up to 30 years in prison. The court had already begun a preliminary examination, hearing testimony from the complaining witness and a police officer. But key forensic reports, including a sexual assault nurse exam and possible DNA results, were still pending. Now, instead of continuing that examination, the defendant is choosing to waive it, which means this case will be bound over directly to circuit court. That's a major strategic move. At stake here isn't just a bond decision. It's whether this case accelerates toward a potential plea deal or a full felony prosecution at the next level. And the tension is only getting started.
Of People versus John Allen Shook. The file number is 252086. FY. Mr. Shook was charged with criminal sexual conduct in the 3rd degree of an incapacitated victim, 2 counts, as a 3rd habitual offender, making that punishable by, I believe, to 30 years in prison. We started a preliminary examination on November 4th. At that time, we took testimony from the complaining witness, Brittany Terry, and Officer Cole Lusby of the Centerville Constantine Police Department. Ms. Terry testified about the events of the night in question, which was October 11th, I think was the date. The officer testified. The officer was about to testify regarding statements made by the defendant, but the court felt there was a corpus delicti issue, that there had to be some showing of the elements of the offense before the statements of the defendant could be admitted. The prosecutor had authorized the matter as they felt appropriate, but often in these kind of cases, it takes a while to get everything. So they were waiting for a sane nurse report, sexual assault nurse examiner, SANE, that had been conducted shortly after this on Miss Terry over in Coldwater, and also waiting for a crime lab report regarding any DNA that may have been found. There was an issue regarding the defendant's bond. I did reduce the bond, which it probably is a good thing because it's been all the way since November 4th to now to get this reset. I was advised, again, before lunch by Mr. George and Miss Canfield. They were working on a resolution that would involve a waiver and a potential plea offer in circuit court. Ms. Canfield has handed me an executed waiver. Mr. Shook, here's what it says. I, John Allen Shook, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. We have appointed Mr. George. Here's the operative language. I voluntarily waive my right to a preliminary examination and understand that it will bound over to the circuit court on the charges in the complaint and warrant, which would be the 2 existing counts of criminal sexual conduct, 3rd degree, unless we amend it. Is that what you wish to do? Yes. You had to speak your answer.
Yes, Your Honor.
All right. Are we amending this or just simply binding it as the 2 counts that are on it?
Binding it over as is, Your Honor. If there's an amendment, I will do so in circuit court after further negotiations with counsel.
All right, waived on today's date, which is 2/10/26, held on 11/4/26 partial. All right, the bond in this matter was altered by me in light of the fact that we had to continue to adjourn it. It was present, it went from 50,000 to 5,000 cash or surety, and the defendant has posted it. Is there anything else we need to address regarding the bond?
Just briefly, Your Honor, and I did have the opportunity to speak with Ms. Canfield about this. Ms. Canfield and I have been discussing this over the past few days, the case in general, but more specifically today. My client has been on GPS Tether since he bonded at the end of November. I think Your Honor had changed the bond approximately November 18th, and I think he was able to bond shortly after that. It's my understanding that there hasn't been any issue. I've been made aware of any type of issue regarding contact with the complaining witness. My client indicates that having the tether on is causing some physical issues. I think he reported that there's a lot of issues cleaning under that. He had cut himself, and we would just ask whether the court would make a determination about the usefulness of the GPS tether at this point. Obviously, my client would still have the continuing no contact order. If he were found to be in contact in any way, he would be subject to be automatically arrested on that and have his bond canceled. He understands that. I went over that with him today. But, like I said, Your Honor, he has been, from my understanding, compliant. I haven't heard anything regarding any type of issues. We just asked the court to make a determination on the appropriateness of the tether. Thank you.
Ms. Canfield, what's your thought?
Your Honor, does the court have any conditions with respect to no contact with minors under the age of 18 or people who are sleeping? Anything other than I see no contact with Brittany Terry, but that would be my concern if there's any modification. I do have what I believe to be credible information that the defendant is residing in an apartment where there are at least 7 minor children present at any given time. And that, of course, is a concern for me with the type of allegations that are pending here. Granted, this alleged victim is not a minor, but when I have any sex offender, it is a concern. So I would ask that if this is amended, which at this point I object to, but if it's amended, that it not be any supervised contact with children under the age of 18 or anyone who is on medication or sleeping.
I'm going to leave the bond as it is, Mr. Shook. I took a leap of faith and reduced the bond by a factor of 10. Truth of fact is you're bound over on 2 counts of criminal sexual conduct in the 3rd degree as a habitual offender. We live in a small county. We don't live very far away from where Miss Terry lives. And I think it's important to have that additional level of supervision. So defendant's request to amend bond to lift GPS tether is denied. Now, I don't know what's next. I do know what's next. They set what's called a status conference. And that could be, if you guys are going to work out some sort of plea agreement, it could be set sooner rather than later. But in the regular course of events, it's going to be weeks and weeks before that status conference is set. We're moving. Judge Stutzman has to dismantle his courtroom and reset it up in Three Rivers. He's doing some things remotely. So if we're already crunched, we're going to be more crunched. So it could be May or even later before the status conference is set. If there is an agreement worked out, but the parties can simply schedule it for something in circuit court. But for the time being, you posted your bond, you've complied with the conditions of it, and I'm going to leave it as set.
Thank you, Your Honor.
All right, thank you.
Yeah.
Angelique, I'll give you this waiver back.
Thank you, Your Honor.
Mr. Marvin always wanted to make sure he got them back to make sure it got scanned in at your office,
Thank
but
you.
then you'll send it back. All right, Mr. Mitchell, Ms. Ives, let's bring in Mr. Chapman.
May I approach her?
Yes, thank you. Here she is. Rondi, do you need a minute to talk with your client, or are we ready to go here?
I did talk to him and back, Your Honor.
Okay, very good. Mr. Cap also had a bunch of cases in front of Judge Pattison, but this one is ours. It's file number 252477FD. We set all these for today for Ms. Ives and for the defendant. This one started out as an operating while intoxicated third offense and resisting and obstructing police officer. Both of those are felonies. The defendant pled guilty to operating while impaired second offense and attempting to resist or obstruct a police officer. Daniel Frazine drew this assignment for the screening report. He's with us by Zoom. Mr. Cap is here in the custody of the Sheriff's Department, and Rhonda Ives is present. He has 70 days credit. He got arrested on December 2nd and has been in custody since that time. Daniel's not recommending a probation. There's other things going on. Ms. Ives, what would you like me to know?
Well, Your Honor, my client does have quite the history. He's had treatment programs before. I feel like he needs continued treatment. I know that he would like an opportunity to do a sobriety court probation. He would like me to respectfully ask this court to consider that. It may sound disingenuous to some extent, but I believe his heart is there, wanting to change, wanting to make a difference in his life. He just needs to have the wherewithal to stick it through. I would like to think that if he was put on sobriety court probation, that he might be able to obtain a license someday. I don't know. I mean, it could be, pie in the sky hopes, but I know that he would like to be considered for that. He knows he's got a lot of baggage underneath him. He just wants to make a change, and that's where we are today, Your Honor.
All right. He told me he's finally figured out why he keeps hitting himself in the head, and I'll be interested to hear him. But let's hear from Daniel first. Daniel, you got anything to add other than just a jail
No, well,
recommendation?
I see that you've already corrected because I had originally had 80 days, but I counted wrong and I checked out my math again. It was 70 as of today, plus whatever good time he got. Um, no, Mr. Cap seemed very nice and very polite when I spoke to him, and he seems to be wanting to do things better. However, um, like for his Muskegon case, he told me that it wasn't cocaine and that they were getting ready to nollie that. When I spoke to them, they were shocked that he wasn't in their jail because his bond got revoked a while ago. He was not in court as on the second when this happened, as he explained to me, but I don't think he was being dishonest. I just don't think he remembers because of all the substance abuse problems he has. It is over 1,000 grams. It's the most I've ever had to deal with, but or in a case or even remotely in contact with. So they said he has a trial date on the 17th of February, and I spoke to them last about a week ago. That's still on their books. They said they had to fix a minimus. I honestly don't even know what the minimus is, but you probably do. So they do have a hold on our jail for him, and they will deal with that. Also, our circuit court wants to deal with him as well because he has several things bound over to them. Realistically, he's done Swift and Sure and a 90-day program all in the last 5 years. If he's gotten it, I really hope sincerely that he has gotten it because he was a really nice, polite person, and I don't wish him any ill. But at this point, in my opinion, there's nothing to do here but give him time served and let him move on to these other big fish that he has to fry, Your Honor.
Bernard, if I may, I forgot I need to correct the report because some of these things are incorrect because they have been resolved.
All right, well, let's talk about that.
Here's where the bond argument becomes critical. The defense is asking to remove the GPS tether, arguing compliance and physical discomfort. Legally, bond conditions are meant to ensure community safety and court appearance, not to punish. But the prosecution raises a serious concern. Credible information that the defendant is living in a residence with multiple minor children. Even though the alleged victim in this case is not a minor, courts often weigh risk factors broadly in sex offense cases. And remember, this defendant is facing 2 felony counts as a habitual offender. The judge already reduced bond from $50,000 to $5,000, calling it a leap of faith. So the question becomes, should supervision decrease when the charges remain this severe? In a small community, proximity matters. And as you're about to hear, the judge decides.
All right, what else? There's a bunch of recent stuff on here. What do you want to correct?
Well, it indicates that there are still pending misdemeanors. I understand that he resolved those misdemeanors, those driving infractions that are spelled out there at the bottom of page, I think it is 4 or 5. He's got and he had a number of misdemeanors, driving infractions. He ended up pleading guilty to 2, and then the remainder, I believe, were dismissed. That paragraph is following the list of priors that he has, which begins on page 3.
We did resolve a whole bunch of cases at once, but then he got this one, and so that is correct. I think we resolve 6 or 7.
And then I understand he also resolved his pending criminal felony charges in circuit court here. And that he's pending sentencing. He pled to an attempted possession of ammunition in circuit court. He's pending sentencing up there.
All right. As Mr. Frazine indicated, he is pending a trial in Muskegon County. And as I understand it, Muskegon County has got both barrels pointed in his direction. Subpoenas have been served and returned, and they're expecting to try this significant case up there. Mr. Cap, you and I have talked to each other a bunch of times, and you confused me. And I said, you got to the point where you just don't care, that you're like doing this because you just don't care. You're driving around Three Rivers where every time they see you, they're going to pull you over. And so, yeah, YOLO, you only live once. But now you've got 70 days of forced sobriety. We can't put you in sobriety court because you got this pending felony in Muskegon. It would, in fact, I don't think we're even allowed when there's a felony pending, but they're serious as a heart attack up there about that case. So in a different world, maybe we would have given this a shot. But you told me you've kind of done some introspection and figured out why you keep harming yourself. What would you like me to know?
Your Honor, I'd like you to know that I've been running from God my whole life, and finally I formed a relationship with him.
He caught up to you?
Yeah. I would have thought it would have been a long time before that, but it just seemed to, I can't get my head out of the Bible, and it's overwhelming. And an eternal love that I've never felt before, and I have love for myself. So
who introduced you at the jail? Did you go to Bible study or something? Or
no,
just...
It's as it sounds. I asked to go to Max, and I sat down and I was comfortable. And the first guard who walked past, I asked for a Bible. Something wasn't right. I was okay with being there. I didn't care about it. It didn't bother me. I was numb to it. I was looking forward to the tray. It was okay. It was okay with me. And when that happened, in that moment, I just asked for a Bible and got my head stuck in it, and I ain't been out of it since. So
it is a learning process. But I'm not going to beat up on you anymore. You got this other stuff pending. We can't do sobriety court. I don't want to jam up Muskegon. I know they've got some, Miss Davis told me they've got several of our officers subpoenaed. A company in Kalamazoo's been subpoenaed. So I want to make you available to them. The fine is $0. You got a bunch of unpaid fines. I'm not going to deal with any of that. I'm going to waive everything but the minimum fee of $125. And I'm going to indicate may be released to Muskegon County.
One question, Your Honor.
Yes.
I have a pending sentencing on the 13th, and I know I have trial on the 17th of this month.
Yes.
I want to know if there's any way for me to be available to Muskegon. I'd like to invoke my 180-day right to a speedy trial.
I don't blame you there. That's a St. Joe County Circuit Court matter. Who's your attorney in Circuit Court?
It would be Knopfsinger, and the judge was inquiring to give me a PR bond on a reinstate bond, but
if he gives you a PR bond, you're going to get shipped to Muskegon.
That's what I want.
And I think what they should probably try to do is sentence you first.
Okay.
But I don't have the authority to do anything with that, but I'll let them know.
Thank you, Your Honor.
Muskegon, you need to get up there and deal with that.
Yeah.
All right, same thing on the R&O. I was going to give you more, but there's no sense in it. 70 days credit, 70 days, $0 fine and costs. Maybe when circuit court is done. $70 days credit, 70 days. We set your bond at $100,000. Now, the blood alcohol was 0.05 something. This is a plea to impaired. But what else did you have in your system? Did you smoke marijuana?
I had the day before. I had court the day before.
And you had your prescription meds as well?
I had not taken any prescription meds in the last couple months. Only thing I've done was smoke marijuana the day before. It would have been the 29th or the 31st or whatever it was before the first. I had court the first, and I went to Muskegon for court. And then when I got home from Muskegon, I had stopped at my mother's and took a drink of bourbon. And then when I was leaving there, I got pulled over.
And you mentioned in there, parents have allowed you to drink since you were about 12 years old.
I mean, my parents in the courtroom weren't, that was not where I lived. That wasn't who let me drink.
Okay, it was somewhere else?
Yeah, I was living with my mother at the time,
Okay.
and a month she worked a lot of hours, and there was alcohol readily available, and I took advantage of that when I was a child.
Boy, you've stolen 47 years of your life. Hope you get some of it back.
Thank you.
All right, you can go with the court officers. Thank you, Daniel.
Thank you, Your Honor.
You didn't do him any favors by letting him drink bourbon that morning. I guess that was his mother again. All right. See what things happen in Muskegon.
By the end of this hearing, two very different but equally serious matters have unfolded. In the first case, the defendant waived his preliminary examination and remains under GPS supervision as the case moves to circuit court on 2 felony sexual conduct charges. In the second case, involving operating while impaired and resisting, the defendant received credit for 70 days served and will be released to face significant pending charges in another county. The judge declined sobriety court due to an active felony elsewhere, emphasizing that rehabilitation programs cannot proceed while major unresolved charges remain. What stands out is a balance: accountability without excess, structure without unnecessary punishment, and a clear recognition of